Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I really appreciate you, and please forgive me for not getting this update done for you last week. I was so swamped at Practical Defense Systems that frankly I just ran out of time. This one might be a little bit longer than normal because I got 2 weeks of stuff to talk about. I won't get to all of it, but I will try to get to as much as I possibly can. First of all, let's talk about Wolford v. Lopez. That's the Hawaii Sensitive Places case that the Supreme Court just agreed to hear. This case asks whether states may treat private property open to the public, like restaurants and stores, as off-limits to licensed carriers of firearms unless the property owner gives express permission. California has done a similar thing, or tried anyway, but essentially what it says is you cannot go into this store or restaurant unless there's a sign that says firearms are welcome here. I don't know what the likelihood of that is, but I don't suspect it's probably going to happen much. But in short, it basically asks the question, does a state get to make your right to carry dependent upon being invited in? That is apparently why they call it a vampire rule. Little did I know that vampires can't come in your home unless you invite them in. Apparently that's a vampire rule. Who knew? The federal government under the Trump administration, thankfully, has taken a clear position in favor of gun owners. The DOJ filed a forceful brief arguing that Hawaii's default ban approach effectively nullifies the general right to public carry, and as a result, it fails the Bruin history and traditions test and is unconstitutional. The Solicitor General says that states can't invert the long-standing presumption that lawful citizens may carry unless specifically excluded by the property owner. Basically, unless there's a sign, as it's been for the last 250 years, unless there's a sign up there that says you can't carry here, by default, you can carry there. That's the way it's always been. Why does this case matter so much? Well, if SCOTUS strikes down Hawaii's vampire rule, that default ban where you must be invited in before you can carry, it could roll back similar rules in California and any other states that decide they want to try this in the future. If the court instead upholds this law, however unlikely I personally think that might be, you can expect states to feel emboldened to expand the sensitive places thing to a lot more places and try to make your ability to carry useless. Either way, the decision is going to set a national precedent about whether carry is a right that existed and exists unless excluded, or it's a privilege that you got to earn by permission. Now, let's just take a quick look at California. The big story here in the last couple of weeks has been Gavin Newsom signing AB 1127. That's a law that bans the sale of certain Glock and Glock-style pistols that the state says are easily convertible to automatic fire using switches. Now, California lawmakers, as usual, have been incredibly hypocritical where this comes because it's been them, the lawmakers, blaming Glock for not updating their designs to prevent conversions to fully automatic using Glock switches. But here's the problem with that. California's own 2001 microstamping law, pushed then by, cackling Kamala Harris when she was Attorney General of the state, effectively froze Glock innovation back to like 1998 models. Any tweak that Glock made, any tweak at all, they could just change the grip texture, for example, would have required Glock to engrave serial numbers on every casing, what's called microstamping. The problem is with that technology that it wasn't viable then, it isn't viable now. It's never been ready for prime time. Even the inventor has testified to that effect. So as a result, Glock never changed the pistols. They needed to sell them, and they stuck with whatever California would let them sell on the roster. So while the rest of America got safer Gen 5 Glocks, California stayed stuck with older models that politicians are now saying are somehow responsible for crime and that Glock has somehow screwed up because they never updated them. So you can see the hypocrisy here. And now they've effectively banned them. So what is the practical result for you? New retail sales of the existing models that are covered by this law will be prohibited starting next year, though existing private ownership is not in danger. So if you already have them, you get to keep them, at least so far. And as far as I can determine, private sales of the guns will be fine, but you won't be able to buy them new. Well, the problem is when they make, we'll get into that in a minute. When they make private sales okay, but new sales aren't, then the price of the private sales tends to go up. Well, in any case, within days of this thing being signed by Gruesome Nuisance, SAF, the Second Amendment Foundation, and the NRA and Firearms Policy Coalition, and I think some others, filed James versus Bonta, a federal constitutional challenge, arguing that the law bans common arms and therefore violates the Second Amendment. I think you can expect more challenges to this obviously unconstitutional law as well. One more thing I should mention about this, I heard this on the range yesterday when I got done with students. As a matter of fact, multiple reports in the firearms trade press and retail circles say that Glock is discontinuing many current models and preparing a redesigned, I think they call it the V series, apparently to avoid running afoul of these new state rules, because obviously what starts in California tends to spread around the country. Retailers posted claims that most Glocks will be phased out and replaced with updated models that alter the trigger back spring geometry so that they can't easily be converted to full auto using Glock switches. However, I want to be very clear about this. I have heard this on the range, and I've seen reports of this from different people, but as far as I can determine, Glock itself has not issued a definitive corporate confirmation that they're going to do this. These are industry reports and retailer claims for now. Nevertheless, they are already affecting dealer stocking and buyer behavior. If manufacturers redesign models to comply with state rules, this is just my opinion flying here, you will see some things happen. One, you will see short-term shortages of these guns, and you will see higher retail sales prices for pre-banned guns, particularly when they are restricted to only private party sales. People who already own them, if they can still sell them, the prices of those are going to go up. And a longer-term market shift where manufacturers produce state-compliant variants every time the state changes a rule may end up with a whole lot of guns that are not yet roster approved in places like California, where they have a limited number of guns that you can buy. That's why legal challenges matter. Courts will determine whether a state can lawfully target an entire family of otherwise commonly owned, commonly sold handguns. It's absurd, and we need the court to come down on the part of gun owners. And one more California note, the Department of Justice recently sued the Los Angeles County Sheriff's Department for allegedly imposing unconstitutional delays for concealed carry processing, for charging too much, and so on. And LA County is not the only one doing that. But this is a reminder that government bureaucracies can and often do obstruct rights by delay and overpricing and so on. Fortunately, the feds, at least under our current president, are now willing to step up and try to enforce the Second Amendment by suing these counties. And it's not just the California Rifle and Pistol Association and other supported organizations that rely on your money, basically, to do this. So let's wrap up real quick. Bottom line, Wolford v. Lopez is the big national case that will determine whether the vampire rule stands or falls. The DOJ is on the side of gun owners, thankfully. SCOTUS will set a national precedent no matter what they decide with that case. In California, Newsom signed the Glock-style ban, and lawsuits are already flying. Expect more of those, and you might want to expect some market reactions and possibly manufacturer redesigns while the courts sort that out. Stay alert, because there might be short supply windows, shifting product lines, and some fast court action, or like most of the time, some very slow court action. But regardless, what this means is that this fight is a live, ongoing fight in both the courtrooms, and you're going to see the repercussions of it in the gun store showroom floor as well. Now, if you support the right to keep and bear arms, I urge you to support the organizations that are fighting for your rights. In these cases, it would be the Second Amendment Foundation, the California Rifle and Pistol Association, the Firearms Policy Coalition, and shockingly, it seems, the National Rifle Association. I haven't seen much of them for a while. If they are actually coming back and fighting, I'm grateful to see it. All right, well, there you go. I did it as quickly as I could. I hope you have a great week. Thank you very much for watching. Stay involved, stay informed, and wherever you go, whatever you do, stay safe.